We're delighted that you've joined us for this webinar to discuss the roles and responsibilities of boards of education in Connecticut. I'm Patrice McCarthy, CABE's Executive Director and General Counsel, and I'm joined by Conrad Valsing, CABE's Senior Staff Attorney. We're going to go over some of the basics of the responsibilities of boards of education, but understanding that specific details will be contained in the policies and bylaws of your individual Board of Education. In Connecticut, the constitutional basis for public education is delegated to the local and regional boards of education for implementation. That delegation comes from the Connecticut General Assembly, and they set the framework within which boards of education operate. The authority of boards of education is primarily contained in Section 10(4)B of the Connecticut General Statutes, as well as Section 10-220. Responsibilities include implementing the educational interests of the state, a very broad responsibility. And then there are many specifics outlined in the statutes. Boards are responsible for the facilities, for making a long-range plan for their school district, as well as for providing transportation for students. There are also many policy provisions that the legislature has prescribed. Sometimes they contain very detailed language, and in other cases, they provide simply that a Board of Education must have a policy on an issue such as homework. Then it's up to the local Board of Education to determine what the parameters of that policy would look like. The policy could be very general and say that the classroom teachers shall determine the amount of homework that will be provided. In other cases, a Board of Education may decide to put some parameters around that, so that in the elementary, middle, and high schools, there would be a differentiation in terms of the maximum amount of time that would be required for homework on a regular basis. The policies that boards of education are required to adopt include graduation requirements, discipline, youth suicide, attendance, promotion, grading, reporting of bus complaints, and all of those boards of education can rely on CABE, for example, to obtain sample policies so they don't have to start from scratch, and so that they can be assured that their policies are actually in compliance with the requirements of the state statutes, but also tailored to their own local decisions. Now, boards of education only have authority when they come together in a legally constituted meeting. So individual boards of education actually don't have any authority. However, you may well find that citizens in your community need to be educated about the role of the board and the scope of responsibility and authority of individual board members. Very often, citizens believe that if they bring a concern to a member of a Board of Education, particularly a newly elected member of a Board of Education, that their issue will be resolved by that individual board member. Of course, you're not able to do that. So if a friend, neighbor, colleague approaches you and says, gee, I'm really concerned about the location of the bus stop, I think it's very unsafe and don't you agree? Your responsibility is not to say, yes, absolutely, and I'm going to take care of that tomorrow. You have a responsibility to help that individual understand where they take that concern. So talking to the building principal, talking to the transportation coordinator in the superintendent's office, that's the appropriate mechanism to make sure that their concern can be reviewed and perhaps resolved. You also, as a Board of Education member, will find people coming to your Board of Education meeting during public participation, raising various issues that they may anticipate the board will be able to respond to on the spot. Public participation at a board meeting is an opportunity for the public to express their views, but there is not an expectation that the board and or the administration would be able to respond to each of those concerns. That's not the best way to get a clear answer. And when you're in a board meeting, it will be your board chair that will help the members of the public understand what the parameters of public participation are and what the appropriate expectations are, which would be that the administration will follow up with the individual about a specific concern after the meeting is over. In your role as a Board of Education member, you represent the community. You don't represent one specific constituency. You don't represent one particular set of political viewpoints. You have been elected to represent the entire community and to fulfill the mission of your district to provide the best education possible for the students in your community. Your superintendent serves as the CEO of the Board of Education. The superintendent is responsible for the day-to-day operations of the school district. And the authority given to the superintendent is also contained in statute, but it is guided by the policies that adopted by your individual Board of Education. So the board is the policymaking body, the governing body, and the superintendent is responsible for day-to-day administrative matters. And that distinction is very important. Obviously, there are some areas that are gray areas, but making sure that your superintendent is able to carry out the mission of the district with sufficient guidance through policy is an important role for the Board of Education. We have seen in recent years increasing instances of lack of civil behavior at all levels of government. This caused CABE a number of years ago to adopt a resolution calling on all public officials to demonstrate civility in all of their dealings. That resolution was ultimately adopted as well by our national association, and many boards of education have developed their own policies addressing civility. Boards of education model the appropriate conduct for their community and for their students. And therefore, their interactions in a civil manner set the tone for the interactions of the entire district, as well as specifically when individuals attend Board of Education meetings and offer their comments to the Board of Education. That civil conduct is what will enable you as a policymaking body to be able to communicate with each other, to hear what your colleagues on the board are saying, and to be informed in your decision-making process. In terms of evaluation, we frequently get questions about what is the role of the Board of Education? Some board members will say, gee, I've always known that that third grade teacher doesn't do a great job. We want to have high standards in our district. How can we make a difference? Shouldn't we be evaluating that teacher? That is not the role of the Board of Education. The Board of Education has one employee, and that is the superintendent. You do have a responsibility to evaluate your superintendent on an annual basis, and that way you set the standard for the entire district. The superintendent is then responsible for ensuring that all of the rest of the staff is appropriately evaluated. It's also important for boards of education to take the opportunity on an annual basis to evaluate themselves. There are opportunities for boards to improve their effectiveness, to improve the way they interact with each other and the way they interact with the superintendent as a leadership team. And reflecting upon that, as well as celebrating the successes of a Board of Education, is a very important function for a board. So we strongly encourage boards of education to do that, and CABE has tools available to assist a board in that process. And we also have members of the staff that can go out and facilitate that discussion with your Board of Education. I'm now going to turn it over to Conrad to talk about the role of the board as an adjudicator.
Okay, so board members have an important role as adjudicators, and since boards are public entities, they must afford what is referred to as due process. If you are new to public service, this may be a completely new concept for you. So if you've only worked in the private sector, due process is something constitutionally mandated, and it generally breaks down into notice and hearing. So when somebody has to be subject to some sort of discipline, the two most important components are notice and a hearing. So in your role as an adjudicator, as a Board of Education member, that's really the hearing part of due process. So the two most common situations as an adjudicator will be teacher terminations and student expulsions, not student suspensions, but student expulsions. So one of the concepts of due process is that the greater the deprivation, as in the greater the punishment, the more process a person is afforded. So once discipline works its way to the board, it will be an expulsion. It will not be suspensions. And expulsions are actually defined very specifically as suspensions 10 or more days. That is constitutionally mandated, and well, through interpretation of the US Supreme Court, the case is called Goss v. Lopez. But basically, anytime a student is excluded from school for 10 days or more, it is a student expulsion, and there is a hearing that needs to be conducted. Statutorily, in our state statutes, the board can actually delegate student expulsions to a hearing officer. So it'll really just be up to your individual district and how you go about expulsions. And a little bit about teacher terminations. In Connecticut, teachers are almost universally unionized. So there will be a grievance procedure that teachers must, go through, and that contractually, when there's punishment, it will have a similar sort of procedure for the teacher being punished and how much notice and process. So the grievance methodology is more about teacher complaints, but then there's also a punishment methodology about how much process they're due. So they both deal with process, and they're both going to be in your collectively bargained contracts, which are another way of referring to union contracts. An important aspect of your role as an adjudicator and due process is that you have to be impartial. And so for these hearings, two important aspects of impartiality is you can't prejudge the situation, and you can't have conflicts of interest with the situation or the people. So, I don't really want to get into the nuances of how you get into those sort of situations, but basically the consequence is that any action you take in a hearing or in a termination, it can be undone if you are not impartial or if you do have a conflict with the person or situation. And so, one of the ways to get around that is you can simply, recuse yourself from the hearing or the process. So sort of on a related note, boards sometimes have to make difficult decisions, and they deal with difficult subjects. But just know that board members are generally indemnified if their actions are not, this is just a technical phrase, wanton, reckless, or malicious, and the action was within your statutory authority as a board or a board member. One exception to the indemnification, which is actually going to lead to the next topic, which is funding, is that there is personal liability if the board overexpends its budget. It's a very serious area of board authority. It is probably one of the, if not the most important aspect of board governance and authority, which is that you will have the ability to, basically set the district budget. There's a process, it has to be proposed. You don't just unilaterally set the budget and then spend the money. This is one of the areas where you will actually, as a board of education within a town or region and several towns, that you will deal with local municipal finance authorities, boards of finance. The board generally proposes the budget, and then it gets submitted to the financial authority, the Board of Finance. And then the municipality itself appropriates the money to the district. There's a lot of nuance to it, but two general things that I think are pretty important is that boards do have the authority to make line item transfers, but they cannot unilaterally carry funds over from one year to the next because the budgeting process is annual. So each year you have to submit that proposed budget to the fiscal authority in your district. And so with that, we will speak about the next topic, which is the advocacy role of Board of Education members and just boards overall.
Thanks, Conrad. As a Board of Education member, you have a very important role as an advocate, and that occurs at the local, state, and federal level. At the local level, you're communicating with your community about the priorities of the board, about the district strategic plan, about the goals of the board, and you're also advocating for the needs of the school system. Is there the need to lower class size? So a budget that would support additional staff members, additional paraprofessionals, perhaps. Are there facility needs? Are you addressing issues of indoor air quality, for example? Those are all things that you need to have an understanding of, and when the board has made a decision that these are priorities for the district, then you have a role in communicating those needs to the community and building the support within your community. Because unlike other states, boards of education in Connecticut do not have independent taxing authority. So you have to have the community's support in order to get the budget adopted that will address the needs that you as a board have identified. It's also very important that boards of education communicate with their legislators. Your legislators represent you in Hartford, and they have been elected by the same constituents that elected you to the Board of Education. So it's important that they have the information when they are considering a variety of pieces of legislation that impact public education. They need to have information as to how that impacts your Board of Education. Does it have a positive impact? Will it have a negative impact? Will it constrain what you are trying to do? For example, every time the legislature enacts a new professional development mandate, that means that that has to somehow fit into the 18 hours of professional development that every district offers. That means choices have to be made. So making sure that legislators understand what their decisions are, how they will impact what happens in your school district, will provide a mechanism to make sure that there is good communication and that good decisions are made at the state level. We encourage boards of education to invite their legislators to a Board of Education meeting. Make sure you get to know your legislators and stay in communication with them throughout the legislative session. They are, Connecticut, considering hundreds, if not 1,000 bills every year, and making sure that you point out to them the impact of the education bills is one of your important responsibilities. CABE keeps Board of Education members informed about all pending legislation that impacts public schools. And so you have those resources as well as our staff available to you to help you in your advocacy efforts. Similarly, at the federal level, we have our members of Congress that rely on CABE as well as their individual boards of education to get information about the impact of proposals, particularly to help them accomplish some of the things that they're trying to accomplish on behalf of our public schools. So that information, making sure that data is available and making sure that those relationships are there so that when you do have an important issue to address, you have the opportunity to communicate with your legislators. Conrad is now going to talk about some of the nuts and bolts of a Board of Education meeting.
Okay, so I talked earlier about due process and how if you're new to public service, whether as an elected official or even public employment, due process is going to be kind of new to you. The other aspect that's going to be kind of new to you is open records and open meetings, Freedom of Information Act laws. So there's a federal Freedom of Information Act, but there's also a state Freedom of Information Act here in Connecticut. So as a school district in Connecticut, you are going to be subject to our state Freedom of Information Act. It's contained in Title I, starts at 1-200, and goes for many more subsections after that. But basically, the two most important components to the law are that the communications and records you have are subject to public disclosure, and then the discussions and actions you take have to be in public. So you have public records and you have meetings in public. So meeting is actually not as obvious as a definition as you think it might be. So yes, when you sit down with the 7 or 9 members of your Board of Education, you are having a meeting, but there's also different ways to have a meeting, which is a little bit tricky because that means there's also other ways you can have an improper meeting, as in having a meeting not in public, which is not okay. So an important concept of meeting is a quorum, which basically just means a majority of your Board of Education members. So if you're on a 9-member board, a quorum is 5. If you're on a 7-member board, a quorum is 4. So basically, when 5 of you on a 9-member board or 4 of you on a 7-member board do anything, act, or even just have discussions, you are having a meeting, which means it needs to be in public and to have been properly noticed, meaning the public must have been apprised of it prior to the action or discussion. So when you have a quorum and you're meeting in person, or you're even just talking, that's the kind of thing that actually gets people a little confused, or maybe even a little bit of, hot water, is that if you're even just talking via email amongst a quorum, or posting on Facebook amongst a quorum, sort of chain commenting on a same news story, and it's related to board business, you're kind of having an improper meeting. So when you have a quorum of discussion or meeting, you're basically having a meeting. There are exceptions, which are hearings and proceedings, which is actually also related to what I was speaking about earlier. When you have those expulsion hearings, you are statutorily allowed to have an expulsion hearing with 3 members of the board, which is less than a quorum, whether you're on a 7-member board or a 9-member board, but that is still a meeting of the board because it is a hearing or a proceeding. So I already spoke about electronic communications. Your subcommittees, some people just call them committees of the board, subcommittees, committees, they're kind of interchangeable terms. But basically, if you have a policy committee or a curriculum committee of the board, and then your board is charging 3 people with being on that committee separately has to comply with the open meetings and open records requirements on their own. So having said that, it's sort of a really high level explanation about sort of how you go about your business of a Board of Education members. The law is merciful a little bit in that certain things you do are just not considered meetings. They just won't be considered meetings. It doesn't matter if you do these in public. It doesn't matter if you do these with a quorum. You are not subject to the meeting requirements. So one of the big ones that I actually kind of get asked a lot is how they talk about things between meetings. So one of the big exceptions to the meeting, it is a non-meeting to talk about agenda. You can talk about what you want to put on the next agenda without talking about it substantively, but you can talk about the construction of the next agenda and what things you should be putting on the agenda between meetings. That is not a meeting. Doesn't matter how many people are talking about it. There is also one that people almost every week try to find some little nuance with, but the caucus exception, which basically means if you are meeting with the same political party members, you will not be having a meeting. One important nuance is that it has to be the same board. So you can't be meeting with your, Republican town committee members and the Republican members of a board. It has to be the same exact board to be a valid caucus exception. So if you have your 4 Democratic members meeting on a 7-member board, that's okay. It's within the caucus exception. Matters related to collective bargaining. Again, Connecticut is a heavily union state, so you will have lots of different unions. You'll have teachers unions, paras unions, administrator unions. When you discuss matters related to collective bargaining, those are not meetings. Chance and social meetings are okay. They are exceptions too. And when you conduct personnel searches for executive level searches, which is primarily the superintendent and vice superintendents. So there are 3 types of meetings. I'm not going to get into the nuances because you will hear it and then immediately forget it once you start your board service and have to be reminded about these types of meetings because they all have very different rules about how they have to be noticed and conducted. So there are regular meetings, which are the meetings you set at the beginning of each year, the meetings you plan to hold throughout the year, and you set a schedule, and then those are your regular meetings. But you can meet at any other time to discuss whatever else you need to discuss between those regular meetings. Those are called special meetings, and they have their own notice requirements about how long in advance you must notify the public that you are meeting for XYZ reason. There's also a third kind that I don't really like talking about because people think they can use it, but it is so infrequently held to be okay that, this is really like a last resort. But there is also something called an emergency meeting, which basically means we can't even give the public 24 hours notice to let them know we are meeting. It is an emergency. We have to meet now. We have to discuss something right now. But there is, just so you know, a way to hold an emergency meeting. So similar to the non-meetings, which are meetings, but they're not subject to the Freedom of Information Act that I was discussing earlier, about discussing notice of the meeting, agenda of the meeting, the caucus exception, but there's also something called executive session. It's contained in Robert's rules. Private entities and organizations can avail themselves of executive session, but there also are very specific executive session rules for public bodies in Connecticut. So there are 5 enumerated reasons that you can enter into executive session. So executive session just means you are at a public meeting, but you then want to have a discussion in private outside of the public eye. One important component of this that you might as well learn now is that you cannot vote in executive session. It is only discussion. So once you remove yourselves out of the public eye, you then cannot vote secretly in that private meeting. It can only be discussion. If a vote needs to follow whatever you discussed, you have to then reconvene in open session. And this can all be done at the same meeting. You'll see that on agendas for Board of Education meetings, you'll have sections related to executive session, or certain items will be, suggested to be discussed in executive session. One sort of quirky rule about it, which is statutorily mandated, is that you need a 2/3 vote to enter. It is not a simple majority vote, as with most other things a board will do. You need to state the reason, one of the 5 enumerated reasons, and again, it's discussion only. So I'll just mention the 5 things. It goes pretty quick. Personnel topics, you have to be discussing an individual. You cannot discuss a class of employees. Like you cannot just discuss math teachers. It has to be a specific math teacher, a specific personnel member. And a little nuance to that is that the person has to be notified that they're going to be discussed, because they kind of have a unilateral right in our state to say, no, I want to be discussed in public. They can sort of veto your decision to go into executive session to talk about them. They can instead ask to be talked in open session. So that's all just one. That's one enumerated reason. Personnel topics, it needs to be an individual. Pending litigation and claims, so it's sort of a legally kind of exception. Matters of security, anything related to security or may, disclose security information, you can meet executive session to discuss. Issues of real estate, specifically when the discussion will, lead to a change in price or availability. And then this last one is kind of a catch-all, but it's important. It's when you need to have a discussion outside of the public because the discussion would lead to the disclosure of exempt public records or confidential public records. So a little bit more about meetings, but if you're not familiar with the term, meetings have to produce minutes, which is basically a summary of what transpired at your meeting. It has to be made available to the public in very certain timelines and with very certain rules. Probably the most important thing in the minutes is the voting. The public has to be apprised of how individual members voted on each action item. Public participation is another really important aspect of meeting in public as a Board of Education. Know that it is not legally mandated to have public participation in our state. However, it is an incredibly good idea, both for later board business and also just for keeping your community informed and in the fold of what the board is thinking about and acting upon. There are policies and bylaws about public participation. And each district will have its own nuanced rules about, time limits and things like that. Boards are generally conducted through what is called parliamentary procedure, which is basically a way of allowing people to speak freely and have a process for getting to the voting on any specific issue. So Robert's Rules is a very common methodology. It's just a form of parliamentary procedure. It's been around for a long time, the 1800s, I believe. Most boards will put it in their policy and their bylaw that they follow Robert's Rules. And it's just a methodology for conducting your business, how motions are submitted, how discussion is conducted, and how voting is eventually held. So that does it for the meeting.
Very good. Well, thank you, Conrad. And we encourage you to watch the CABE website for professional development opportunities, which we offer on an ongoing basis, webinars, in-person meetings, as well as the annual CABE CAPS convention, because it's important that board members build a strong board and superintendent leadership team. And one way to do that is through engaging in professional development. On behalf of the CABE staff and board of directors, we wish you well in your board service.